Poverty is not just the absence of money, but the absence of opportunity. And the United States is a country where you have both freedom and abundant opportunities. Moving to the United States has given me both. I grew up in Lagos, Nigeria. I came from a close-knit family. I was the third of four children. And the best thing that my parents gave me was the gift of education. Even though I came from a poor family, they gave me education with the instruction that this is the tool that will help me to dig my way out of poverty and ignorance. But what my parents did was that they instilled in us the value of faith, hard work, and not giving up. They made us realize that if you put in the work, you will definitely get the reward. I came without a dime in my pocket. All I had was big dreams, determination to succeed, and the resilience. I got my first job at the age of 14. My job was on a construction site. My duties were to move concrete on a large pan from one end of the construction site to another one. I worked on that day from around 6 in the morning to about 7 at night. At the end of the day, the employer refused to pay me. And the reason was because she did not authorize the foreman to hire me. So I worked from sunup to sundown and didn't get paid. That tore up my spirit. And from that moment on, I decided that I was going to become a lawyer. And I was going to use every ounce of strength within me to fight against injustice, regardless of how powerful the opponent is. I am a man that worked my way up from nothing. I know what it means to feel like you're being unfairly treated, and I'm the person that can stand up to opponents regardless of how big or how powerful they are. Welcome to another episode of Legal Angle with Emmanuel Olawale. I have Tiffany Cruz with me today, and she's an employment rights attorney. She represents employees. And if only I knew someone like her at the age of 14 when I was cheated by that employer, I would have gotten the justice that I desired at that time. Welcome to the show, Tiffany.
Thank you, Emmanuel. It's so nice to be here. Thank you so much for having me.
It's so nice to have you. Can you tell us a little bit more about yourself? Who is Tiffany Cruz?
Sure. I'm obviously an attorney. I do employee rights work for plaintiffs. And I was watching your video and I thought the same thing. I said, man, that cannot happen. You cannot not get paid for your work. That's the type of work we do, actually. But uh, more than being an attorney, I'm a mom and a wife. I have two kids that are 8.5 and 7. And I love doing that. That's probably my greatest job. And like you, I decided to become a lawyer. A little bit different story. Obviously, I was born in the U.S. My dad was in the military. We moved around a ton, but I decided to become an attorney because I wanted to help people and fight injustice. And that's exactly what I'm lucky to do every single day.
Mhm. Wow. Where did you grow up?
Well, that's a funny question. People ask me this all the time. Where are you from? I'm kind of from all over the place since my dad was in the military. I've moved a ton. I spent a lot of time in Florida. I was born in Maryland, actually, at Andrews Air Force Base, and we split my life between Virginia and Florida with a little bit of time in Hawaii in between. Um, and so I spent my formative years, which I would call elementary school, in North Florida, and then a couple years in Key West. And then middle school, we lived in Virginia, and then back to Florida for high school. And I stayed in Florida to go to college as well. And so I've kind of been all over the place.
I understand. What was it like to be a military daughter?
It's a good experience. I think that it helped me in a lot of ways, be a lawyer. You have to adapt to changes all the time. We moved every 2 to 3 years, so I constantly had to make new friends. I had to, meet new classmates, be in new situations. You see lots of different backgrounds, so I loved that. And my siblings are significantly younger than me, so they kind of had a different experience. They kind of grew up in one place the whole time because it was kind of towards the end of my dad's career. So it's been an interesting dynamic to see how our experiences were different. Um, but it definitely gave me, I think, some advantages in life of learning to adapt. Like when I went to college, being able to adapt to those different situations and really be open-minded to other people's situations and their lifestyles, and just differing opinions. So I was very thankful for that experience for that reason.
Thank you. How how did moving around as a kid affect you in the way you relate to people or in your relationship?
I think it helped me or forced me really to get out of my own comfort zone, right? You're especially for little kids, they tend to hang out with the same people all the time. Well, I would have to find those new people every few years. But it definitely helped me become more social, even though by nature, I guess I like to be around people, but I would say that I'm kind of more of an introvert. So it has helped me to get out of that comfort zone. Um, it definitely helped me when I started my own business because my own law firm, so much of it is about networking and going, around and talking to people that you don't know. And I can see that difference in my own children, right? Because they've kind of lived around the same people their whole life. And, they're not as comfortable talking to new people in different situations. So I think it did help me with that. My social skills were much more adaptable. I was more comfortable, walking into a room of people I don't know, maybe than some other kids and college students and high school students my age.
What was high school like for you?
Probably like it was for everyone else. I don't know. I'm not sure I would repeat high school. uh, High school, what do I remember the most about high school? I remember in high school, my first year of high school, I did ROTC, which is like the military program in high school, and I thought it would be good. Obviously, I came from a military family, so it seemed natural to me, but I knew pretty quickly I wasn't going to go in the military. And I don't think that my dad necessarily wanted me to do that either. Um, but it gave me some discipline, like when you're transitioning from middle school to high school. I had fun in high school. I had a lot of friends, and but then by the time I was a sophomore, or finishing my sophomore year, I started to kind of transition for college prep. That's really when like dual enrollment was becoming a thing. So I took a lot of college courses in high school so that I could finish college sooner. Because I knew that I was going to go to college and I knew that I would have a professional degree. At the time, I thought I was going to go to med school, but that did not that did not pan out for me. I was not that great at math, so I enjoyed my time in high school. I did a lot of fun things and had good experiences. And I kind of grew up in a sleepy southern town, sort of. Um, and so I thought we had a fair amount of diversity, which I really enjoyed in high school. And I think it helped me have a good experience going to college, transitioning to college.
Thank you. And you just mentioned that you were thinking of becoming a medical doctor, then you ended up becoming a lawyer. What
Mhm.
attracted you to the study of law?
Oh, yeah. I mean, I think I always liked it. I always watched the shows that everybody watched. The shows will get you first. That's how everybody gets into something, I guess. I loved like that you could be creative and think of ways to solve a problem creatively. And it doesn't have to be through litigation. It could be through litigation, but creatively doing it through litigation. Uh, I loved learning about the cases and really how you could change the laws through the practice of law. And so when I realized medicine was really not the best route for me, law was kind of a natural transition. And luckily, when I was in undergrad, they had a legal studies program, so I could take courses to see if it was something that I really loved, which I did. And I took those first few classes and I just fell in love with it. And that made it pretty easy to transition from there. Um, and I knew like that I was going to love that career, not because I like to argue. uh, Although, that is part of the job. I think it's more advocating than arguing, but that does become part of the job. But I just loved dissecting problems and helping people come up with a solution.
What are those TV shows you used to watch that inspired you to seek
Oh man, I knew you were going to ask me
becoming a
that.
lawyer?
I was like, he's going to ask me what shows it was, and I'm trying to remember the shows that would have been out at the time.
I
I
used to
don't.
watch The Practice.
Yeah, The Practice. Okay, that was a great show. Now there's like even better ones. I think The Lincoln Lawyer, which is actually a really decent show. I mean, I didn't do criminal defense work, but I was a prosecutor at one point, so I can kind of recognize all of those things. Yeah, probably The Practice, I would say, was the big one. Of course, I watched Grey's Anatomy, which made me want to be a doctor. That didn't work out so well, but the practice seemed to work. Practice seemed to work out. Yeah, I enjoyed just watching those different things. I mean, I probably did watch some Perry Mason and all the ones that people think about, but not nearly as much as The Practice.
Yeah, I understand.
Good memory.
Yeah,
That's a good
I used
memory.
to watch The Practice. I used to watch Matlock, and
Yeah, Matlock.
yes, yes.
Actually, a show that I used to watch, and she's not a lawyer, but was Murder, She Wrote. Have you ever watched that? Because it's all about, she solves crimes and she solves mysteries. So that show was always fascinating to me because she, could just use her skills to come up with a problem solving scenario.
Good show. Yeah,
Mhm.
I watched Columbo as well. He used to solve crimes. One other
Yes.
thing.
Mhm. Yep. Columbo. Yep. That's so
Yes,
funny.
yes. Okay, and then after you got your bachelor's in legal studies, you
Hmm.
decided to pursue your master's degree, but
I
not in
did.
law, but social work. Why social work?
Yeah, that's a good question. I just have a heart for service, and I had all the way through undergrad. During my undergraduate degree, I had always volunteered as a guardian ad litem, and so I really had a passion for social work. I loved um, helping children, and really, it's a topic area where you're really affecting their lives greatly. Social workers can. Um, so I was interested in that. I did a policy specific track. So uh, I went to FSU to get my master's degree, and they had two options. You can become a clinical social worker, which is like what you'd think of, like a therapist or counseling, and other careers within that, or you can do the social policy track where you would be kind of more in the management side, affecting policy and change. And so I was interested in doing that work because I was doing a lot of the hands-on client-facing work already through my volunteer time. And I really enjoyed the program, actually. Uh, it was very challenging, and I would say my time in my social work program, which was 2 years, probably helped me grow as a person the most. It forced you to challenge like your own beliefs, the things that you grew up believing or learning, and to really hear the ideas and values of other people in depth, and challenge your own beliefs in that way. And maybe you don't change your mind, maybe you all agree to disagree, but it definitely taught me about being respectful of other people's opinions and how other people can think differently than you. It doesn't make them wrong that you just have different thoughts and ideas about things, which, was very helpful into growing you as a more well-rounded person.
And by the time you decided to go to law school, you've already had your first degree in legal studies, you've had masters in social work, you've also worked. So, which makes you a much more mature law student. What was law school like for you?
Yeah, I think I would not have been prepared to go to law school straight from undergrad, which is the traditional path that most people take. So when most people start law school, they're like 21 years old, maybe 22. I think I was 25, 26 years old when I started law school. So I had gotten a master's degree. I had worked full-time all the way through undergrad and graduate school. And then I worked for 2 years after graduate school before I went back to law school. How did that help me? I would say immensely. I actually started law school in a part-time night program because I was working full-time. And so a lot of my students, the other students in my classes were also working, but a lot of them had transitioned straight from undergrad. And so the volume, I mean, you know this, the volume of work in law school is so immense and intense. A lot of people struggle with that because you have to be very disciplined. I felt like my time getting my master's degree and then being a professional, having worked a professional job, really helped me to just be very diligent about my studies. And I was working during the day that first year, so I really had no other option but to be very strict with myself. But it helped me just, I think, process the information differently. I had done a lot of work in graduate school that requires some of those same skills and study habits, which I felt like helped me perform, better in law school and just be prepared for the volume of work, especially when I transitioned to full-time in law school and stopped working. And I transitioned full-time my second year and third year. And I took an extra course load so I could catch up from being part-time. That really helped me. Yeah, I don't
Wow.
recommend it per se, taking 18 credit hours in law school, but I wanted to finish still in 3 years. So I don't think I would have
Yeah.
been able to do that had I not worked and gone to graduate school before. I think I would not have been prepared or as mature or responsible.
Wow. That's awesome. And what was your first job as an attorney like?
I was a prosecutor as my first job right out of law school here in Tallahassee in the Second Circuit. And I thought I would do that job forever, honestly. I loved being a prosecutor. It was probably next to what I'm doing now. Obviously, I love my job now. It was just a fun job. We worked with wonderful people. We had such a fun experience. It's sort of like when you start college, you have like a class of people that you start with, and you're all learning together. You're new, most of you right out of law school. It's everyone's first lawyer job. You're learning how to be a trial lawyer. You're getting thrown into trials. Literally, you might walk in the morning and you're in trial within an hour. I mean, there was no better learning experience, I think, than for being a trial lawyer than being a prosecutor or public defender for that matter. I think those two jobs can really prepare someone who wants to be a trial lawyer. And so I just had the best time in that job. I loved it. I literally couldn't say one bad thing about that job. The caseload is heavy. I mean, that's true. But it was such a great experience. I did so many different things. I did trial. I got to do mental health court when I was there. I was the prosecutor in charge of the mental health court division, which I loved. That like filled my social work passion. I got to write appeals. I did all of the appeals for county court while I was there, which I don't love legal research and writing that much, but it challenged me to work on a part of my skills set that I didn't really enjoy, and I was thankful for the experience in the end, for sure.
Yeah. Wow. How long did you work there for?
I was there for 2 years as a prosecutor, and then I went out to civil practice, and that's when I started doing employment law.
Oh, That's awesome. Let's watch a short clip, then we'll be right back.
Okay.
It was an easy decision for me to choose to help employees versus employers. My nature is to help people who are in need. And employers are in need of representation too, and there's plenty of attorneys that do that. My heart is with helping the underdog. I have always just felt drawn to righting those wrongs where I can.
Growing up, I was taught to be empathetic and also fiercely protective over the people that I care about. I try to utilize that in my practice area when my clients come see me, to be empathetic to the situation they're going through. When our clients come to us, they're feeling helpless. They don't really know where to turn. Really what they're trying to figure out is, how am I going to put my life back together? And that's kind of where we come in. We want to help take that burden off of them, work with them while they're trying to put their life back together, find another job, get unemployment. They can be focusing on those things while we handle the legal aspects of everything. That kind of protectiveness comes out when I'm representing a client.
A few years ago, I was sexually harassed by a high-level official, and it put me through extreme distress, and I wasn't really sure how to handle it or what to do next. My biggest fear was that it was my word against my employers, and I was a subordinate, they were my superior. You know, who's going to listen to me in this position? I didn't know where else to turn. So I reached out to Cruz Law. I first met with Tiffany and Cruz Law. Her and her team listened to everything that I had to say. They were very reassuring. They told me that they would handle everything, which even included communicating with all parties involved. It was wonderful meeting with them. Life now is back to normal. I've been able to transition back into the workforce, and I couldn't have done it without Cruz Law Firm.
A lot of times when our clients come to us, they're in the dark about what to expect. With Cruz Law, we want to shine a light on that right up front so that they know what to expect going forward.
It can seem impossible to an employee when they think, how would I ever prove that I was discriminated against? But that's what we pride ourselves on. We will prove those things. We can prove those things, and we do that every day for employees.
What a powerful video.
Thank you. It even makes me emotional a little bit watching it still.
So what inspired you to start your own law practice?
To start my own law practice, so I guess I'll back up just a little bit. I left the state attorney's office and I worked for a civil firm that did employment law. And I really enjoyed it there. They mentored me and I loved working there. I got recruited to go to another law firm after about 3 years to start an employment law practice at a different firm. And I did that transition. I became a shareholder at that firm, and I was there for about 7 years and enjoyed that a lot. But it was just time for me to leave that firm and start my own practice. And so that I could serve clients the way that I wanted to serve clients. And I think that was one of the greatest inspirations to do it. My team, I had a team of myself and a couple other lawyers who honestly really encouraged me to do that. And that's probably the greatest gift about owning my own practice, is that I get to decide what my client's experience is like, how we are helping them every step of the way, which is very important to me. It's a really traumatic time of their life. Most of the time our clients have been fired, or they're being treated in just the most egregious ways because of things they can't change about themselves: their race, their gender, a disability, their age. They're being sexually harassed. And so, they're in a lot of distress, and I wanted to be able to say, here's the experience I want to give you while we're helping you put your life back together. And now we're able to do that.
Why did you decide to represent employees instead of just maybe both employers and employees?
Sure. Well, I mean, that's how I started when I went to civil. The firm I worked at represented only employees. And so that seemed like a natural transition. It certainly could be easier sometimes maybe to represent employers. They're usually insured and you work for them, you get paid by the hour instead of contingency. But it's kind of like what we talked about in our video. That was genuine. Those videos aren't scripted, you know that. I want to help the people that need the most help, and I want to help the person who is fighting the uphill battle. A lot of times for us, it's a David and Goliath situation, and we're the David, and so it can be fun to help, and I use that term loosely. It's exhilarating to be on the downside of something. Employment law, the laws are generally not favored for employees. But that's the challenge, right? It's challenging and it's exhilarating to be able to put the evidence together and really make a client feel like they got some justice at the end. And so I think we do that better on the employee side. Yeah, we help a few employers. It would be disingenuous to say that we don't. We do have a few employer clients, but they're like personal friends who own businesses, and they align with our vision in that they want to be good to their employees, and we help them to create policies and practices at their workplace. We have a small handful of small businesses that we help we put the policies together to create the environment that's a good and healthy one for their employees.
Thank you. Most employments are at will.
Mm-hmm.
So which means that the employee can decide to quit at any time and the employer can decide to fire at any time. But what are those rights that employees have in spite of the at-will situation between them and the employer?
Sure. So Florida is an at-will state and a right-to-work state, both. And there's a difference. So an at-will means you can be terminated for any reason that's not an unlawful reason. And you can also leave your employment for any reason that you want to. That's what at-will means. And a right-to-work state just means that you can't be forced to be part of a union to work in this state. So your job can't force you to unionize. People think that at will means that you can just be fired for any reason at all, and that's too broad. That's not right. That's not accurate statement of the law. You can be fired for any reason that's not an unlawful reason. So your employer can't fire you because of your race or your gender or because you're pregnant or because you needed an accommodation in the workplace or you needed to take medical leave. They can't fire you because you reported wrongdoing or in retaliation for reporting discrimination. Those things are all unlawful. So lots of employers will say, oh, well, it's at will, your job is at will, and we're terminating you. They're not ever going to say we're firing you because you're a woman or because you're pregnant or because you're Black or Asian. That's our job to figure out if that's what happened and then to show that was the reason motivating them and that it wasn't really because it's at will, so to speak.
So how do you determine the intention behind the termination when it is not explicit in the letters, in the emails, or in the fact? How do you go about doing that?
That can be hard. I would never tell you that it's an easy position to be in, because you're really having to try to get into someone's brain, into their mind, like what was motivating that person to act this way or make this decision. So like many things, you can either have direct evidence or circumstantial. Direct would be them saying, I'm firing you because you're a woman. That happens very rarely. I can think of very few cases in the last, 10 years that there's been true direct evidence that way. Most of the time we're proving it by circumstantial evidence. And so we look at course of conduct. How did they treat other employees that had the same or similar type behavior as our client? And were they of a different protected category? So if we'll just use gender as an example, because it's easier to use. If they say, like, my client was constantly tardy and it's a woman and she got fired for that. Well, did they fire the men that were constantly tardy? You're going to look at emails. How is the communication happening? Other internal documents, we read every document. There may be thousands of documents produced in every case. I mean, we'll check every one. Was there some indication that our client had complained, or did our client tell us that they complained about discrimination and then they were retaliated against for that? We look to see, did the employer document the complaint? Was there any indication on the termination paperwork that they had considered the fact that the client had made a complaint prior? And we look for all of those things, statements from people who used to work there. We even look at other lawsuits, if there's been other cases filed against them, to see if there's some type of pattern. Those can all be great areas for circumstantial evidence to prove discrimination claims, but they are difficult to prove, but we do it.
Thank you. Will an intern qualify? Let me put it this way. Can you file a claim on behalf of an intern?
Sure. Yep. That's the broad answer is yes. It depends.
Okay. Tell us what it depends on.
It depends on a lot of factors. So you can have an intern if it typically if it is not something that you would otherwise pay someone for that work. You can't really control a lot about. There's all kinds of internships that go through educational programs, and very obviously those people can get credit through their university for the internship. So that follows that guideline. We've had interns before too, but you can't use an intern in place of a staff person just to avoid paying them. So, there has to be very little control on the side of the employer or the intern place, because they're an intern. They can do whatever they want to do. They can come and go kind of as they please if you're not paying. There's lots of guidelines, and that would fall under the FLSA and wage and hour components of the law about interns.
Okay. Let's say, for instance, an intern comes into the workplace and they get sexually harassed or discriminated against. Will they have a cause of action against the employer, even though they're not technically employees?
They could. On the sexual harassment example, it's a good example because sexual harassment usually the employer could be liable for that, yes, for the sexual harassment. Let's say they get sexually harassed, they report it, and the employer or intern place doesn't do anything to rectify it, then yes, they can be liable for that. If there was a touching involved with the sexual harassment, then you have issues for the employer or internship host, I'll call them, and the person individually, right? So the individual can be liable for the touching. So there's several areas of liability when it comes to sexual harassment specifically, because it typically involves a touching. It doesn't have to have a touching. So we're very clear, and then people that listen to your podcast will know sexual harassment does not have to involve a touching. It can be just words and actions. So yes, I would say the employer employers need to be aware of that and should be enforcing their sexual harassment policies, even as it relates to interns. They may not be getting paid and they're not maybe a W-2 employee, but they would still have some rights in that regard.
So how will, in a situation like that, how will damages be determined?
Good question. I haven't had an intern specific case like that, but typically damages are governed by lost wages. So you'll have back pay and front pay. And then you, of course, can get emotional pain and suffering damages. If it's a private employer, you can get punitive damages. So probably in that scenario, right, they're not losing pay, but they probably could have emotional pain and suffering damages. There can be punitive damages, especially if they reported it and the employer or internship host did nothing to rectify the situation or address it, and then the actions continue to happen. That would give, I would think, at least you have a good argument for punitive damages in that scenario against the employer, because then the action becomes willful and malicious, or could become willful and malicious. Those are probably going to be your big drivers for damages when there's not actual monetary loss. That would be true on the battery as well, right? The battery, if they had physical injury, certainly, then, you can have medicals just like in a personal injury case, but most of the time it doesn't rise to that level exactly. But you could have medicals for therapy visits or counseling, different types of treatment that you may have to seek as a result, and all of that would be recoverable.
What if the employer is a government agency?
If the employer is a government agency, and this won't necessarily be unique to sexual harassment. So if the employer is a government agency, you are eligible to get all of the same damages depending on the type of claim it is that you would if it's a private employer, except for you cannot get punitive damages. So no punishment damages against a government employer. And then in Florida, we have caps on damages. And I don't know if you have those, but if you sue the government in tort, there's a cap on damages at $200,000 or $300,000, $200,000 or $300,000 per occurrence. So we do run into that it will apply to the employment claims as well. The judges have, and a lot of the circuits have applied it to some of the employment claims. So if you can get a federal law claim in there, that helps. It's why a lot of our stuff ends up in federal court, especially if it's against a government entity. So I would say more of my practice is in federal court than state court. It's started to shift to be more 50-50. Now in our state, the summary judgment standard is now the same in state court and federal court in the last couple of years. So I would say that has made the practice be a little more equal, both state and federal, whereas before it was more federal driven. It would go faster. And now the courts have standing case management orders here, so everything kind of moves on the same time frame.
So how do you decide whether to pursue a state claim or a federal claim?
If I have a government employer or a state actor, and I have the ability to bring a federal law claim, I'm probably going to bring it in federal court directly. I don't file it in state court and then let the defendant remove it. I'll typically just file it directly in federal court. If I don't have, there's a few claims where it's only a state court cause of action, so you have to be in state court. If you're against the government, then we just have to file it in state court. If it's a private employer, we just decide, depending on what the issue is, what seems better for the case, whether it makes, because the laws pretty well track each other and the case law pretty well tracks each other. So we kind of just make a decision, maybe on our caseload, maybe on what the rotation is at the time, that it makes more sense to be in state court or federal court some move, sometimes one is moving faster than the other a little bit. The cases can move a little quicker. If the client needs it to move a little quicker, we might file in one or the other. If I think that the defendant is going to move it to federal court, even if I file it in state court on a removal, I'll just file it in federal court so we can avoid that delay, basically, of time.
Thank you. To avoid the delay. So federal court moves faster.
Typically. I would say typically.
And when talking about federal cases, can you handle cases from other jurisdictions outside of Florida?
I can if someone pro-hawks me into their jurisdiction, which I will do that. And we do that all the time. Florida, doesn't have reciprocity with any other state. So we can't get licensed. I mean, we have to take another bar exam to get licensed in another state. But often, if you had a case, for example, and you wanted me to work it, you would just have to pro-hawk me in there. And we do that with lawyers all over the place, especially in Georgia.
So when you're saying pro-hack, for a lot of people listening to this, they might not know what that means. It means that you will co-counsel on the case and will apply for a special permission from the court for you to be able to represent that client in that jurisdiction.
Yes, exactly. I would say, I'm going to practice in your state. I'm not licensed in your state, but you are going to certify to the court that you're going to basically be responsible for me under your license.
Thank you. And what are the elements of a whistleblower case?
So it will be different everywhere. In Florida, we have a state statute for the Florida Public Whistleblower Act, and then we have a Florida Private Whistleblower Act. So it's different for private employers versus public employers. And now you're putting me on the spot. So the most important thing to remember for private employers is that it should be in writing. So you either need to report in writing a violation of a law, rule, or regulation. We recommend that everyone put those reports in writing, both private employers and public. Public employers have to report to very specific entities or persons within their organization. They could also report it to the Attorney General's office. And then a public employer has to be reporting a violation of a law, rule, or regulation that could affect the health, safety, and welfare of others. And they get very specific statutory protections as a public employer once they've made a whistleblower report. Private employer employees, there's basically 3 categories, but they fall under 2 primary categories. They report in writing or threaten to report in writing a violation of a law, rule, or regulation, or they object to something, a policy or practice of the employer that's a violation of a law, rule, or regulation. Those are the 2 primary under a private employer. Unique in Florida, I don't know if other states have this, but if you're a public whistleblower, so this is not federal government whistleblowers, but if you're a public whistleblower, like you work for the state or a local government, and if you work for the state, this doesn't apply to local government employees, you can get reinstatement to your position. If you got fired from the job for the reporting, you can get reinstatement to your job while the lawsuit is pending, which is unique here. I don't know if other states have it, but I know Florida does.
Thank you. You mentioned that the report has to be in writing. And these days, writing can be in different forms. It could be a letter, it could be email. Is text also acceptable as a form of writing?
The argument has been made. I need to honestly check on the status of that, if there's been any recent decisions on it. But yeah, writing is construed very broadly. Email definitely counts. Arguably texts count. Traditional writing counts. Because email, this got litigated several years ago because the statute requires a signed writing. Okay, so email that counts as a signed writing. We encourage everyone to put their complaints in writing for numerous reasons, some of which are obvious, which is that there's a documentation, whether a whistleblower or not, that you made the complaint. So if your employer, if someone at your employer is mistreating you, discriminating against you or retaliating against you, you should report that in writing to Human Resources. If it's whistleblower, you need to report it in writing to the appropriate identified person pursuant to their policy and pursuant to the statute. Ultimately, I just tell people, if you have a question, you should call an employment attorney and ask first. But, writing is always better. Having something in writing. An email is great because it's time-stamped. We know who you sent it to. They really can't dispute that you sent it or submitted it, right? And so that's why we highly encourage people to always put it in email.
Thank you. What's a non-compete agreement?
Yeah, a non-compete, or they call them restrictive covenants, or non-compete. It's essentially a mechanism to impede your ability to work for another employer who does the same type of business as whatever employer is asking you to engage in it. So, and it'll be for some period of time and a distance, and it will outline the types of conduct that are impermissible, the type of work that's impermissible. That's generally what a non-compete is. So like in Florida, lawyers can't have non-competes. So that would be unlawful for a lawyer to have a non-compete, but plenty of other jobs have them. And they're presumptively valid. So you should assume if you sign one that the court is going to assume that it's valid. It may get reduced later, but people always think, oh, I sign it because they're not valid. That's not true. Yeah.
And how are damages determined when someone violates a non-compete agreement?
Sometimes it's determined by the contract itself. There may be a liquidated damages provision. Otherwise, damages will be determined they're hard to determine, which is why there's liquidated damages provisions a lot of times. But other times it can be if the non-breaching party, which would typically be the employer alleging a breach, if the employer says they lost business, for example, as a result of the competition, they would need to identify how much business they lost, or, there has to be some way to quantify that. That's why there's typically a provision about how those damages are hard to quantify. Here's the remedy if it's breached.
Thank you. What happens if an employee gets injured on the job? What rights do they have?
So assuming that your state, which Florida has workers' compensation laws, most states I think do have workers' compensation laws. If you are injured on the job, you have the right to be compensated for that injury and to have your medical care covered. So if you get injured on the job, you need to report it immediately to your employer. Most states require that you go right away, one to a physician or medical care center to get treatment, but they're also going to most of the time require you to take a drug test to see if you were impaired while on the job, and that's part of a workers' comp claim. In Florida, you cannot be fired for making a workers' comp claim. And so we do have workers' compensation retaliation protections here. And so of course, the injury process, once you make the claim, it'll go through the process with their workers' compensation carrier of the employer. And, they'll determine if they're going to cover the claim or not. And if they don't, then I always encourage people to seek a workers' compensation attorney, specifically that handles the benefit portion. We don't do benefits, but we do handle cases where someone has been terminated because they made a workers' compensation claim or they're otherwise being retaliated against.
What if the employer couched that termination as because of poor performance or any other kind of infringement or violation of the work rules? How do you handle those kind of cases?
They will couch it that way. Most certainly, that's how that's going to happen. So it's kind of similar to the discrimination claims, right? We're looking to see, is this conduct that is otherwise allowed or tolerated within the employer with other employees that were not injured on the job? Is it behavior that the client, the injured client themselves, have engaged in previously and they were not disciplined? But once they were injured and made a workers' comp claim, now that's become a problem for the employer. I mean, you're looking for all of those different dynamics, whether there's even validity to the things that they're saying about poor performance, which comes through testimony and documentary evidence, both other employees. We'll look at other workers' comp claims that have been filed against the company. Have they terminated other employees who filed claims? Even if that employee didn't bring forward a claim that they were retaliated against, you want to check kind of the pattern. If historically, all of the people who've made comp claims, are they not working there anymore? That may lead you to believe that there's some practice that they're firing or otherwise getting rid of employees who make claims.
What is the process of starting an employment violation or employment rights case?
So the process is a simple one, and it's probably much like any other case. Typically, we get called when someone's been fired or terminated from their job. That's I would say the majority of the time that we get a phone call. That's the impetus or the spark that kind of sets them off to call a lawyer. Sometimes people call when they start getting the treatment in the workplace that they think is wrong, or they're noticing that they're being targeted a little bit more, or they're getting in trouble for things that other people aren't getting in trouble for, or they reported something and now they notice that they're getting retaliated against, they're getting written up, or they've been placed on kind of some discipline performance. Those tend to be the things that kind of start someone's path to looking for a lawyer. And then when they call our office, we do an intake with them, whether they've been terminated or not. We do an intake with the potential client. If it's something that, something's happened and we determine that there is a cause of action, then we'll accept that case. It could also be a situation where it's not quite to the place where there's a cause of action yet, but there is what I like to say, that it doesn't pass the smell test, right? Something's wrong, something's going on, but maybe it doesn't quite meet an unlawful standard. And so we'll guide people, here's what you should do. And then if you notice any of the following actions or these things happening, then you should call us back and do a follow-up. And largely, we will always encourage people to report any discriminatory actions or retaliatory actions that they think are happening to them.
Thank you. And what is the intersection between employment law and civil rights?
Yeah, so, the federal statute under which we practice is the Federal Civil Rights Act. So, I mean, that's the broad, I would say civil rights is the big picture and employee rights falls under that. But there's so many things that fall under civil rights, so many different types of claims. And I mean, we could never possibly do all of them, but civil rights could be like a false arrest claim, right? Violating. It could be a 1983 action, excessive force. I would categorize all of those as civil rights claims. A lot of the cases that we've heard about in the media for the last few years relating to police and minorities, civil rights claims. So you can kind of see how broad it is, but employee discrimination claims are also civil rights claims. And I think civil rights is just more broad. I mean, it's any kind of violation of your rights, I would say, based on an immutable characteristic. So a characteristic about you which you can't change, right? It's not, it's just it's who you are at your, in your core, at your everyday. And it's not like I wore a red shirt today or a green shirt today, and they don't like me because of that. That's not a civil rights violation, but I'm a white, or I'm a woman, or I'm disabled, those would be civil rights.
Thank you. You've had over 50 jury trials that you've tried to verdict. And just recently, you won a case, with damages topped over $1 million, and it made the news. Tell us about this case and what makes you so good at trying these cases.
Well, I'm passionate about this case in particular. So I'll just give you a little basic of what the case was. It started out as a race discrimination and retaliation case against the state, a state agency, and my client worked there in human resources, of all places. And she started to kind of notice that she was being held to a different standard based on her race. And she reported that. She knew to do that. And then she started to be retaliated against as a result of that. I'm really condensing it, but we lost the race discrimination claim on a pretrial motion. And so the only thing that went forward to trial was the retaliation claim. And we presented that to the jury. The defense put forth a lot of evidence, good evidence too. It wasn't a slam dunk. They had witnesses that said that my client had lots of performance issues. Some of them we could explain, and some of them, it was for the jury to decide if they believed the evidence that the defendant put forward. And what I think makes us so successful is, at least we were lucky enough that a juror contacted us after the trial to kind of talk to us about it, which was really wonderful. And the jury just, he explained to us that we put forward a really good timeline of evidence. And, we find the little things. I think that's what helps. It's important. Every little document. In this case, there was a document that showed that the employer, despite them denying this, had clearly considered the fact that our client had made a discrimination complaint when they terminated her. And we used that in closing, of course. And so the juror said for them, it was just that the reasons that the employer gave were just too unbelievable. Our client had been a well-performing employee for many years, and then she starts making these complaints, and now suddenly she was terrible, and they just could not believe that. The damages amount, we did get $1 million verdict in this case, and the jurors just were very concerned about how it had impacted her. It was primarily emotional pain and suffering damages, and that was the largest portion of the verdict. And they were very concerned how it had impacted her at the time it was happening and how it was impacting her going forward. And, she was later in her career, and so they took that into account, it sounded like. And so they wanted her to be set on the best path moving forward after what had happened to her. And she had worked for the employer that we sued for since 2008, and I think her termination was in 2018, so about 10 years. So that was a long time. That's not an insignificant portion of time, to be knowing whether an employee is a good employee or not, and to have dedicated your career to. So it had a big impact on her, but we got a good result for her.
Congratulations on that verdict. And how can people reach you?
So the best way to reach our firm is the phone number that you see there, 850-701-8838, and you will talk to Kira, who is our intake specialist. She's wonderful. And Kira will get some basic information to get to me and or Kevin. You could also visit our website, which is tiffanycruzlaw.com. And then we're on Facebook and Instagram and TikTok and Twitter.
Thank you. And what does it mean for you to come on Legal Angle to talk to our audience?
Oh my gosh, I'm just really so honored to be here. I think the world of you, Emmanuel, we've gotten to know each other over the last year. And I just think you're such a wonderful person and a great lawyer. And when you asked me to do this, I'm just so honored, honestly. There's probably 1,000 other more deserving people who have more interesting things to say than I do. But I am just so delighted to just have a platform to talk with you and to your audience about what their rights are. So thank you.
Thank you. It's an honor to have you on the show as well. And for those of you watching us at home or listening to this as a podcast, we appreciate your time. Until next time, take care. Bye for now.